Namaskar, friends. Welcome back to Corporate and Securities Law Compass. Today, we are discussing an extremely important SEBI circular issued on April 7, 2026, relating to relaxation from penal provisions applicable to non-compliance with minimum public shareholding requirements. This circular provides significant temporary relief to listed companies facing difficulties in achieving minimum public shareholding compliance due to volatile market conditions and global uncertainty. Let us understand the entire circular in a practical and simplified manner. First, let us understand the meaning of minimum public shareholding, commonly known as MPS. Minimum public shareholding is one of the most important compliance requirements applicable to listed companies in India. The concept is governed under Rule 19A of the Securities Contracts Regulation Rules 1957, Regulation 38 of the SEBI Listing Obligations and Disclosure Requirements Regulations 2015. Under these provisions, every listed company other than certain public sector companies is generally required to maintain at least 25% public shareholding at all times. This means minimum 25% of the total issued share capital of a listed company must be held by public shareholders. Now, the next important question is, who are public shareholders? Public shareholders generally include retail investors, mutual funds, foreign portfolio investors, insurance companies, domestic institutional investors, non-promoter shareholders, and all investors other than promoters and promoter group. Promoters, promoter group, and persons acting in concert are excluded from public shareholding. Now let us understand why MPS is important. SEBI introduced minimum public shareholding requirements to ensure adequate public participation, fair market practices, better liquidity in shares, proper price discovery, improved corporate governance, reduced promoter concentration, prevention of market manipulation. Suppose promoters hold 95% shares in a listed company. Then only 5% shares remain available for public trading. This can result in low liquidity, artificial price movement, excessive promoter control, and unfair market conditions. Therefore, SEBI mandates minimum public participation in listed companies. Now let us understand how companies normally achieve or restore MPS compliance. Listed companies may use various methods permitted by SEBI, including offer for sale, qualified institutions placement, institutional placement program, follow-on public offer, rights issue, promoter stake dilution, secondary market sale, preferential issue to public investors subject to conditions. Now let us understand what happens when a company fails to maintain minimum public shareholding. If public shareholding falls below the prescribed threshold and the company fails to restore compliance within the permitted timeline, then strict regulatory actions may be initiated. Under the SEBI Master Circular dated July 11, 2023, stock exchanges and depositories can initiate various penal actions including levy of fines, freezing of promoter shareholding, freezing of promoter Demat accounts, restrictions on transfer of promoter shares, withholding corporate benefits, restrictions on further securities issuance, and other consequential regulatory actions serious. These actions are extremely serious because they directly affect promoters' management control and market reputation. Now let us understand why SEBI issued the recent relaxation circular. SEBI received representations from industry bodies and market participants highlighting practical difficulties faced by companies in restoring minimum public shareholding. The difficulties arose mainly due to volatile market conditions, concerned, unstable investor sentiment, reduced market liquidity, geopolitical tensions, uncertainty arising from Middle East developments, pressure in capital markets. Because of these factors, many companies were unable to successfully complete offer for sale transactions, qualified institutions placements, institutional placements, promoter stake dilution exercises, and other fundraising activities. After considering these concerns, SEBI issued Circular number HO/49/1414 2026. CFD POD 2 I 8772 2026, dated April 7, 2026. Now let us understand the most important relief provided under this circular. SEBI has granted temporary relaxation from penal provisions applicable to non-compliance with minimum public shareholding requirements. This relaxation applies to listed entities whose due date for achieving MPS compliance falls between April 1st, 2026 and September 30th, 2026. This 6-month period is extremely important. If a company's MPS compliance deadline falls within this period, then penal actions prescribed under the SEBI Master Circular shall not be initiated during the relaxation window. This means no freezing of promoter shareholding, no freezing of promoter Demat accounts, no levy of monetary penalties, no consequential regulatory restrictions under the Master Circular. However, remember one extremely important legal distinction. SEBI has not waived or removed the minimum public shareholding requirement itself. Companies are still legally required to restore and maintain prescribed public shareholding levels. Only the penal consequences have been temporarily relaxed. This distinction is very important from examination perspective, interview discussions, practical compliance, board reporting, and secretarial practice. Now, another important relief granted by SEBI. The circular also clarifies that penal actions already initiated between April 1st, 2026 and the date of the circular may be withdrawn. This is a major operational relief. Suppose promoter shares were frozen, Demat accounts were restricted, fines were imposed, regulatory actions were initiated. Such actions may now be reversed or withdrawn by stock exchanges and depositories in accordance with the circular. Now let us understand the role of stock exchanges. SEBI directed all recognized stock exchanges to inform listed entities, publish the circular on their websites, amend bylaws, regulations, and operating procedures if required, and implement the circular immediately. This means implementation responsibility primarily lies with stock exchanges and depositories. Now let us understand the practical impact through an example. Suppose a listed company was required to restore 25% public shareholding by June 2026. Due to weak market conditions and poor investor response, the company could not complete offer for sale, qualified institutions placement, promoter stake dilution, or institutional placement. Under normal circumstances, severe penal actions would have commenced immediately. But due to this SEBI circular, penalties are temporarily suspended, promoter shares may not be frozen, additional time becomes available for strategic planning, distress stake dilution may be avoided. This helps companies restore compliance in a more orderly and commercially practical manner. Now let us understand the legal authority behind this circular. The circular has been issued under Section 11 of the SEBI Act 1992, Section 11A of the SEBI Act 1992. These provisions empower SEBI to protect investor interests, regulate securities markets, issue binding directions, and ensure orderly development of the securities market. Therefore, the circular carries full legal authority. Now, let us discuss an important misconception. Some people may believe that SEBI has permanently relaxed MPS norms. That is incorrect. The circular only grants temporary immunity from penal consequences during the specified period. Companies must still eventually restore minimum public shareholding compliance. Serious. Failure after the relaxation period may once again attract strict regulatory action. Stern. Now let us understand the broader governance perspective. Through this circular, SEBI is balancing two important objectives. First, maintaining regulatory discipline and investor protection. Second, providing temporary flexibility during extraordinary market conditions. This reflects a practical and responsive regulatory approach. SEBI is not eliminating compliance obligations. Instead, it is acknowledging temporary market challenges faced by listed companies. Now, some important practical guidance for compliance officers and company secretaries. Even though penal actions are temporarily relaxed, periodic disclosures must continue. Stock exchange intimations must continue. Continuous monitoring by the board must continue. Efforts toward restoring compliance must continue. Companies should never treat this circular as a permanent exemption from compliance obligations. Now let us quickly revise the key points. Question: what is the relaxation period under the circular? Answer: April 1st, 2026 to September 30, 2026. Question: does the circular remove minimum public shareholding requirements? Answer: no. Only penal actions are temporarily relaxed. Question: what actions are relaxed? Answer: fines, freezing of promoter shareholding, Demat restrictions, and other penal actions under the master circular. Question: can earlier penalties already initiated be withdrawn? Answer: yes. Actions initiated between April 1st, 2026 and April 7, 2026 may be withdrawn. Now let us conclude. This SEBI circular provides major temporary relief to listed companies facing practical difficulties in restoring minimum public shareholding compliance during volatile market conditions. However, MPS obligations continue. Only penal consequences are relaxed temporarily, and companies must still restore compliance within applicable timelines. For listed companies, promoters, compliance officers, merchant bankers, company secretaries, and securities law professionals, this circular is extremely important from both legal and practical compliance perspective. Understanding such regulatory relaxations is essential for effective corporate governance and real-world securities law practice. Thank you for watching Corporate and Securities Law Compass. If you found this discussion useful, then like, share, and subscribe for more practical discussions on SEBI regulations, Companies Act, corporate governance, listing compliance, fundraising, insider trading, takeover code, and securities law updates. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.